Hi, today we will be discussing Chapter 9, Law, Investigation and Ethics. We will be reviewing some of the information privacy laws covered in this chapter. I am Kester Rawlins and this is iTech 360. Review laws of Trinidad and Tobago and internationally. There are many types of legal systems in the world that differ in how they treat evidence, the right of the accused, and the role of the judiciary. Some of the different types of legal systems are common law, Islamic and other religious laws, and civil law. Here we will be discussing some of the types of legal systems. First, we will be looking at the Sharia's law. The Sharia's law is known as the religious law of Islam. In a classical form, the Sharias differ from Western systems of law in two principal respects. In the first place, the scope of Sharias is much wider since it regulates the individual's relationship not only with neighbors and with the state, which is the limit of most other legal systems, but also with God and with the individual's own conscience. The religious law of Islam is seen as the expression of God's commands for Muslims and in application constitute a system of duties that are incumbent upon all Muslims. Another type of legal system we will be looking at is common law. Common law is used in Trinidad and Tobago among other countries such as the United States, United Kingdom, Australia, and Canada. Trinidad and Tobago uses the English common law system, whereby there is a judicial system. The Supreme Court of Judicature comprises the High Court of Justice and the Court of Appeal, and has establishments in Port of Spain, San Fernando, and Tobago. The Court of Appeal is presided over by the Chief Justice and hears appeals from the High Court and the Magistrate Courts. In some circumstances, appeals may be made to the UK Privy Council. The courts of summary criminal jurisdiction and petty civil courts are presided over by magistrates. The courts of summary jurisdiction deals with criminal cases and the petty civil courts with the less serious cases. The Chief Justice and judges of the Supreme Court are appointed by the President of the Republic, after which consulting with the Prime Ministers and leaders of the opposition in respect of the Chief Justice, and the Judicial and Legal Commission. So, let's review the common law system under the United States. Under this system, there are three branches of government that makes the law. These branches are the legislative branch, the administrative agencies, and the judicial branch. The legislative branch makes the statutory laws. The administrative agencies create the administrative laws, and the judicial branch makes the common laws found in court decisions. Compilation of Statutory Law. What is a statutory law? This is a law. It is a written law passed by a body of legislature. Statutory laws which are arranged in order of amendment, or are statutory codes that arrange the laws according to subject matters. In the United States, At the federal level, for instance, the session laws are found in the statutes at large, known as the states. The statutory codes are held in the United States courts, known as the USC. We will be seeing some of this abbreviation in the upcoming slides. The statutory laws for the states are arranged in two categories. Federal statutes are usually cited to the United States Code, and this citation contains the following elements, such as the code title number, that is, each title is grouping of statutes dealing with a particular subject matter, the abbreviation of the USC, the statutory section number within the title, and the date of the edition of the supplement. So an example of this is, you might see something like 18 USC 1001 and you may have 1992 in brackets. This simply is, that would refer to section 1001 in Title 18 of the 1992 edition of the United States Code. Title 18, if you reference, would refer to crimes and criminal procedures and many more computer crimes prosecuted under this title. The U.S. Computer Fraud and Abuse Act that addresses the use of federal interest computers to commit fraud can be found as 18 U.S.C. 1030 open brackets 1986. Other titles probably would follow as Title 12, which would be Bank and Banking, Title 15, Commerce and Trade, Title 26, Internal Revenue Code, or Title 49, like Transportation. So another aspect of the compilation is the administrative law. Compilation of administrative law. Administrative laws are also arranged either chronologically in administrative registers or by subject matter in administrative codes. At the federal level, these arrangements are respectively called the Federal Register, known as FedReg, and the codes of federal registrations, which is, you would see in later down in the slide, CFR. A citation to the Code of Federal Regulations includes the following: the number of the CFR title, the abbreviation for the code, CFR, the section number, and the year of publication. Let's talk about compilation of common law. Common law is compiled as case reporters in chronological fashion and in a case digest arranged by subject matter. The main categories of law under common law system, not to be confused with common law resulting from court decisions, are criminal law, civil law, and administrative or regulatory law. Criminal law. This is laws about individual conducts that violates government laws enacted for the protection of the public. Punishment can include financial penalties and imprisonment. Civil law. Laws about a wrong inflicted upon an individual or organization that results in damage or loss. Punishment can include imprisonment, but financial awards comprises of punitive, compensatory, or statutory damages can be mandated. Administrative or regulatory law. Standards of performance and conducts expected by government agencies for industries, organizations, officials, and officers. Violation of these laws can result in financial penalties and imprisonment. So let's see. Civil law. The civil law systems are used in countries such as France, Germany, and Quebec. Civil law systems rely on written statutes and other legal codes that are constantly updated and which establish legal procedures, punishments, and what can and cannot be brought before the court. In a civil law system, you may have a judge merely establishes the fact of a case and applies remedy found in the coded law. As a result, let's say lawmakers, scholars, and legal experts hold much more influence over how the legal system is administered than judges. Yeah, really something else. Let's look at intellectual property law. Let's start with patent. Sure, many of you may be here about patents. You design something, you say, well, let's get a patent for it. So you take out a patent so that no one else can manufacture or make anything close in relation to what your product or design consists of, right? So let's get the official definition of a patent and what does a patent provide. So a patent provides the owner of the patent with a legal enforceable right to exclude others from the practicing the invention covered by the patent for a specific period of time. Patent laws protect inventions and processes such as utilities. So you would have a utility patent and ornamental designs, which would be known as design patents. Pretty interesting. In the United States, as of June 8, 1995, there were utility patents for a period of 420. This book, where we gather the information from the CISSP Prep Guide, edition of 20 years from the date of application, right? So more or less the Prep Guide has a patent for 20 years from the date of when the application was filed. For patients in force prior to June 8, 1995, when the Patent Act was established, all patents granted on applications pending before that date, the patent term is greater than 17 years from the date of issue. The term under prior law or 20 years from the date of filing. Design patents are granted for a period of 14 years. Once a patent on an investigation or invention or design has expired, anyone is free to make, use, or sell invention or design. The aspect of intellectual property law is copyright. Copyright protects original work of authorship. It protects the right of the author to control the reproduction, adaptation, public distribution, and performance of these original works. So when we hear about copyright something that you created to prevent unauthorized duplication of that, right? So we're looking at trade secrets. What are trade secrets? These secures and maintains the confidentiality of proprietary, technical, or business-related information that is adequately protected from disclosure by the owner. Corollaries to the definitions are that the owner has invested resource to develop this information, it is valuable to the business owner, and would be valuable to the competitor, and it is non-obvious. So you can have that, you can copyright your trade secrets. Some of these are established in colognes, the actual chemical or the actual composition of the cologne, those could be known as trade secrets as well. Form of intellectual property law is a trademark. This is simply a word, a name, a symbol, color, product shape, device, or combination of these that will be used to identify goods and to distinguish them from those made or sold by others. So, for example, Nike trademark would obviously be the Nike tick. You would have Adidas with the kind of flower looking icon. Apple, a trademark of Apple, of course, would be the Apple symbol, right? So all these are legal intellectual properties of the company that design products and offer services. Let's move on to another aspect known as information privacy laws. This is simply the protection of information on private individuals from intentional or unintentional disclosure or misuse is the goal of the information privacy laws. So let's see what the European Union has on privacy laws. Well, we already know that information privacy laws were there to establish the protection of information on private individuals from intentional or unintentional disclosure, right? The intent and scope of these laws widely varies from country to country. The European Union has defined privacy principles that in general are most protective of the individual's privacy than those applied to the United States. So, in a nutshell, the European Union takes privacy laws more serious than the United States. European Union principles, when it comes to information privacy laws, we can see that, well, here we have a listing of some of the principles as defined, right? So one of the principles are data should be collected in accordance with the law. Also, information collected about an individual cannot be disclosed to other organizations or individuals unless authorized by law or by consent of the individual. That sounds pretty good and sounds something that is important when it comes to privacy. If we examine personally, we sure we won't want our personal information to be out in the public domain just like that, right? So another principle they go by is records kept on an individual should be accurate and up to date, right? Individuals have the right to correct errors contained in their personal data. Sounds fair enough. So doesn't mean that you have data on someone and the data is incorrect. Because in the event of this needs to be released, it would be releasing wrong things or wrong data, which could probably implicate the person and stuff like that, right? Form or another principle when it comes to privacy laws with the European Union is that data should be used only for the purpose for which it was collected, and it should be used only for a reasonable period of time. So doesn't mean if you have data on something or someone now, it is valid to be used next 5 years or even next 6 months in the future. Individuals are entitled to receive a report on the information that is held about them. It makes plenty sense, right? Transmission of personal information to locations where equivalent personal data protection cannot be assured is prohibited. These examine, listening to some of these principles here, we can see that the European Union have strict penalties or strict laws when it comes to privacy and information about individuals. Let's examine some of the European Union's healthcare principles. One of the main principles are the protection from disclosure and misuse of private individuals' medical information is a prime example of a privacy law. Some of the common healthcare security issues are as follows, right? Most times you would hear in medical institutions or ministries, the disclosure of patient information is strictly prohibited. The European Union has adopted this strategy as well when it comes to disclosure of health care principles or healthcare information about individuals. We can see some of the other principles, what they have outlined here. Access controls of most healthcare information systems do not provide sufficient granularity to implement the principle of least privilege among users. Most off-the-shelf applications do not incorporate adequate information security controls. Systems must be accessible to outside partners, members, and some vendors. Providing users with necessary access to the internet creates the potential for enabling violations of privacy and integrity of information. Criminals and civil penalties cannot be imposed for the improper disclosure of medical information. We will now look at some of the other European Union's healthcare principles. Some of these would include one of a large organization misuse of medical information can cause the public to change its perception of the organization. Healthcare organizations should adhere to the following information privacy principles based on European Union principles. An individual should have the means to monitor the database of stored information about themselves and have the ability to change or correct that information. Information obtained for one purpose should not be used for another purpose. That is so self-explanatory, right? Organizations collecting information about individuals should ensure that the information is provided only for its intended use and should provide safeguards against the misuse of this information. The existence of databases containing personal information should not be kept secret. That point, let me just explain that point for instance. If that is not how it sounds in terms of they're collecting information on databases and keeping it secret from the public, right? Basically, they are just trying to explain there that if there's a system within a healthcare institution or within the government to collect personal information on patients or individuals, the individual should know that this database exists. It should not be kept in hiding. Or for instance, if you go into a medical institution and give your information, they have the right, or the individual have the right to be informed that the information being collected would be used and contained on a database. That is basically what that last point there is trying to explain when it comes to privacy laws. In information privacy laws, the US have some acts or laws that caters for this as well. So we'll just be looking at the US Kennedy Casey-Bond Health Insurance Portability and Accountability Act, known as HIPAA Public Law 104-191, effective August 21st, 1996. This act addresses the issue of healthcare privacy and plan portability in the United States. With respect to privacy, this Act states no later than the date that is 12 months after the date of the enactment of this Act, the Secretary of Health and Human Services shall, 422, the CSSB Prep Guide Edition, submit details, recommendations on standards with respect to the privacy of individuals' identifiable health information. Let's view another section of information privacy laws when it comes to electronic monitoring. Information privacy laws covers electronic monitoring. When discussing this, there are personal security issues that should be covered under electronic monitoring. Some of these would include keystroke monitoring, electronic monitoring, surveillance cameras, badges, and magnetic entry cards. Some of the key issues that are covered under privacy laws in electronic monitoring are that the monitoring is conducted in a lawful manner and that it is applied in a consistent fashion. With regards to email, an organization monitoring employees should have the following: inform all that email is being monitored by means of a prominent logon banner or some other frequent information. To explain that a little bit, in an organization where you have email monitoring, there should be a prompt, or when the user or the employee logs onto their email, it should notify them that some form of monitoring is being taken place. Monitoring should not be done unknown to the employee in the background when it comes to email, which in terms of information privacy laws. The banner should state that by logging on to the system, the individual consents to electronic monitoring and is subject to a predefined punishment if the system is used for unlawful activities or if the user violates the organization information security policy, as explained earlier. It should also state that unauthorized access and use of system is prohibited and subject to punishment. The employee needs to be notified of this in order for this to be effective and when catering for the privacy of individuals. So it doesn't mean that you're working in an organization and they can monitor you without letting you know you're being monitored. There are laws, there are privacy laws to cater for this. We will just basically recap what electronic monitoring for employees should encompass. We should ensure that monitoring is uniformly applied to all employees. Explain what is considered acceptable use of email systems. Explain who can read the email and how long it is backed up. And not provide a guarantee of email privacy. Let's look at two terms that are used in information privacy laws. We have enticement versus entrapment. What is enticement? Enticement occurs after an individual has gained unauthorized access to a system. The intruder is then lured to an attractive area or honeypot in order to provide time to determine the origin of the intrusion and eventually identify the intruder. Simply explaining, this is where you set up information or you have an arena where you can lure the intruder in and then identify them. A simple example of this is let's say cheese on a mouse trap, right? Entrapment, on the other hand, encourages the commission of a crime that the individual initially had no intentions of committing. Entrapment and enticement. Let's move on to another aspect known as P3P. What is P3P? P3P is the platform for privacy preferences. Let's see. Platform for Privacy Preferences was developed by the World Wide Web Consortium known as W3C to implement privacy practices on websites. An excerpt of the P3P specification states P3P enables websites to express their privacy practices in a standard format that can be retrieved automatically and interpreted easily by user agents. Sounds cool. P3P user agents will allow users to be informed of site practices in both machine and human readable format and to automate decision making based on these practices when appropriate. The latest W3C working draft of P3P is P3P 1.0, January 28, 2002. With P3P, an organization can post its privacy policy in a machine-readable format known as XML. We may hear of XML format on its website. So let's look at this diagram, which represents the platform for privacy preference statement. So you would have who has access to the collected information, the type of information collected and how the information is used, and the legal entity making privacy statements. P3P also supports user agents that enables a user to configure a P3P enabled web browser with user privacy preferences. In this slide, we would be looking at some of the computer security, privacy, and crime. Let's just summarize some of these, right? So in 1970, there was a law where the US Fair Credit Reporting Act covers consumers reporting agency. Here we can see some of the laws that were listed, just to name a few. We have the 1970 US Racketeering, Influence, and Corrupt Organization Act, known as RICO, which address both criminal and civil crimes involving racketeering, influencing the operation of legitimate businesses, crimes cited in the act including mail fraud, securities fraud, and the use of computer to perpetrate fraud. In 1973, there was also the US Code of Fair Information Practices, which applies to personal record keeping, just to name a few. In 1984, there was a law known as the US Medical Computer Act. This addresses illegal access or alteration of computerized medical records through phone or data networks. Then there was another one in 1986, which covers US Electronics Communication Privacy Act. Basically, this prohibits eavesdropping or the interception of message contents without distinguishing between private or public systems. The rest of these laws are in detail. It can be found in pages 426 to 430 in the CISSP Prep Guide Gold Edition. Thank you for listening, and that was chapter 9 covering law, investigation, and ethics. I'm Kester Rawlins, and this is iTech 360.